Coming to you straight from the Rio Grande and beyond. Broadcasting to the four corners of the globe. So grab your seat, your coffee, or your sundowner.
Okay, everybody, here we go.
On point, as always. This is Gloves Off. Gloves Off.
Back at you in Gloves Off, and today we have a great guest, Bridgette Davis, who is another victim of the courts here in the U.S., and we're going to touch base on issues that go on with the courts and things that people should look into, see if you're if you have a court case at this time or gone through it, because there's a lot of discrepancies that apparently are being brought to light. How are we doing today?
I'm good, thank you. How are you?
Good. Well, tell me a little bit. How did you find this out, and what is it that we should be looking
at? Okay, so I have been embroiled in state court for 5 years now, and throughout my court case, I started noticing certain clerical markings on the filings, which led me to understand that they were how they were processing my filings through their administrative process. And all of my filings, as it turns out, were not being processed as state court adjudication. They were being processed as private mediation. But unbeknownst to me, no one told me. I believed, and they were acting as though we were in state court. So that led me to examine how my entries were endorsed, how all the judge's orders were signed. And then that led me into the research and rabbit hole of case law. And I ultimately did, stumble upon case law from the 1800s, from 1887. And the particular case is Carper v. Fitzgerald from the United States Supreme Court. The opinion was entered March 28th of 1887. And it basically says, and I've posted this on my TikTok, but I don't know if people can see it, but when your judge signs a judgment or an order or an entry with just their name and their title, circuit judge or district judge, that endorsement is not of a court, that is of the judge. And I kept further research. Article 3, there was this congressional act, the Judiciary Act of 1789, that is the act when Congress conferred the governmental power of law to the Supreme Court. So the judicial body, they do not have the governmental force of law or the power. They can only apply the law on behalf of the court to which they are an officer. So it's sort of like a slight clerical technicality, right? How they endorse that opinion, everything above their signature designates their jurisdiction, or they need to invoke the court when they sign, because that's saying this is the court's entry, and everything that I have said and how I have applied the law is in my power to do so because I serve on this court. So this basically says that when they sign, just Judge so-and-so of the Superior Court or of the District Court, and they do not specify of, like I live in Hamilton County, of the Hamilton County Common Pleas Court. And then it needs the seal, but we can get into that a little bit later. I've discovered some more information about a court seal and whether or not There is a law requiring it. But this basically is the case law that says that's not of the court. That's basically has no governmental force of law. And every single state is writing millions of these judgments and adjudicating. So if they're not invoking the jurisdiction of the court, then they're operating completely and totally in administrative capacity. And then that means that they lose their immunity. This is what they're saying when they say void of any jurisdiction. If you are void of any court and you're operating in your administrative capacity, and you are dealing with issues of law like property transfer or child custody or, I'm blanking, sorry, where they force the man to pay, child support. Thank you. Anyway, they're writing those entries and signing them in their administrative capacity. But do you see how I'm saying? Inflating one power that they have and utilizing the ability that they have to control the record and the process behind the scenes. So the record shows the judge entered an administrative order. Well, an administrative order is scheduling a hearing, having a status call, something like that. It is not deciding and adjudicating child support or transfer of deeds or custody. So that's how they're getting us all in this conundrum, which is legal fraud, all by a simple omission of entering and signing as the officer of a court.
Now, before we continue, let me ask you a couple of questions. So let's just put it back in here for those people trying to see where we're headed. So if a judge of, let's just say, Webb County Court 1, just signs his name, whoever the judge is here at Webb County Court 1, just signs his name, Judge so-and-so, and does not put what the court that he's representing underneath, that's a null and voided motion?
That's an order by a judge and not of the court. So back to Carper v. Fitzgerald. It literally says that if it's signed Hugh L. Bond, circuit judge, that is before the judge sitting as a judge and not as a court. So the only place that we have written down law is in Article 3 of the Constitution, where it specifically states that power of governmental law was conferred to the Supreme Court, to the court. So they designated, it does not make, it further states, it does not make his decision as judge a decision of the court. So
now here goes with this. Now, if that judge signs it without his title of what he represents, the court that he's overseeing, but yet it is documented, whether in some counties it might be the county clerk, in some counties it might be the district clerk, and it's signed and sealed by them, would that make it legal?
No. And the reason that you're not going to have, and I have on my TikTok asked people once I read this, you need to get a certification from your county clerk of courts. So here's how they're keeping this all sort of confusing and covered up, because you have the clerks of the actual court that you are in. For us, it's the Domestic Relations Division of the Common Pleas Court in Hamilton County. Then they have their own clerks. And they will stamp and certify anything, any document that comes out of that adjudication, because they're basically saying, yep, this is a record that we have. But Federal Civil Rule 58 requires that a final judgment be what gets recorded. And final judgments cannot be recorded. Judgments, rather, any judgment cannot be recorded unless it's of the court. So the county clerk is, like, for example, in Hamilton County, that is a separate elected official.
Sure.
And if some counties are smaller, they may be appointed, but it is an entirely separate office. It is under the superintendence of your state court system, but it's a separate guy. And that's the guy that takes all of judgments of the court that are proper and executed correctly and memorializes them in the county journal. So the county journal consists of all the records from the civil to the criminal, all those. So if you file a public records request to your county clerk, the clerk of courts for the county, they need to issue a full certification that, that officer, the person who holds that office, I solemnly swear, blah, 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 this has been recorded. I recorded it because that's my duty, not a deputy clerk, that guy. And what they're doing is they'll put that stamp on a deputy clerk's signature. So you will never get the county clerk of courts to swear under oath that judgment has been recorded. What they will do is take a clerk from the county court and they will stamp it. It's certified, it's our judgment. So it gets even more confusing because here's what happened in the 1789. I could be wrong on that date exactly, but here's case law in Re Kaine from 1852. It's stated in this, but you can see this case law is big. Anyway, this is another case to the United States Supreme Court in which they said this judgment came from a circuit judge in vacation, meaning without his court, so we can't review it. We can't administer justice. We're only given the power per the Constitution, per the Congressional Act of 1789, to look at a judgment from a court. If a judge signs just his name and his title, nobody can do anything about it, even the United States Supreme Court. But in here, it talks about the original treaty between us and Great Britain called the Jay Treaty. And back in the day, when you read this old case law, this is why attorneys will insist, don't read anything past 1960, before 1960. You know why? Because they gave you the law in their opinion. They explained. They weren't operating this giant fraud. They were actually applying law, and they used stare decisis, meaning we're going to pull some previous opinion and cite that to support how I'm applying the law. That's basically what case law is for. It's for the judiciary. It's not for us. It's for them. You tell them your injury, and they have to apply the law, and in doing their application, they will invariably say, well, we have to support, this is the previous guy's opinion, and here's why I'm using it, because I agree with him. So in the Jay Treaty, they specifically laid out the form required for governmental documents, court documents to be accepted and authenticated between the two nations. And it specifically said, by my hand, with the seal of the office, or the seal of the court, and certification of the clerk. That's why the county clerk is important. That has not changed. There has to be that witness, if you will, under sworn testimony. So it was signature of the judge, seal of the court that he's an officer of, and the clerk saying, yes, that is the judge. He did sign under oath, and that's the court that he's an officer of. And then that document could be given full faith and credit in between the nations. What they did when they devised this system was obviously that treaty became obsolete over the years because it was only between Great Britain and our country. We have a lot of other countries that we do business with, and we, need our documents to be accepted. So they have revised it in, I believe, 1961. I don't know, I could be wrong with that date, but it's around that time. Then we have the Hague Convention. And the Hague Convention, Congress decided that they were going to put a buffer in between. We're not going to keep this language in the treaty anymore, in the specific agreement, because the agreement as a treaty is law. That's our law, just like our Constitution is our law. So the judges would have to follow that treaty. So they took that language out and they inserted language that said, you will have to obtain a document called an apostille from your state, or if it's a federal document, from the U.S. Department of State. Mm-hmm. And that apostille is an authenticating document. And it will just say, and it's interesting how, the bar people, the lawyers, craft the language, because the language is, it will authenticate the judge's signature. So it's not authenticating the court. Do you see how they left that out? It's not authenticating that, yeah, that's a judgment from a court. It's just saying, yeah, that's the judge. So that is a judge. And that is not the same things. But in doing so, they took away the stipulation as law, because we have the supremacy clause in Article 6 of the Constitution. So anything that is a federal law supersedes any state, any law they write. Well, the states now write, well, it's too much money to include this seal of the court on issuances like warrants and summons. So we don't need that anymore. They could write those laws because it's not in the treaty. It's not specified in that federal law anymore. We don't have a law. They got rid of needing the seal, in my opinion. So all that is left is to ask the federal court and pose the injury in such a way that it becomes a federal question, a constitutional question. Is this document, I believe this document is not in compliance with, or is a violation of Article 3 of the U.S. Constitution. It's a nullity. It is not a court. And, the argument is, do you come with all of this case law? Do you put all this case law in your complaint? Personally, I believe no, because case law is, again, judicial opinion. It's not mandatory. And any judge at any time can say, yeah, that was that guy's opinion, but this injury has a totally different set of circumstances. And, the elements of the law are clear, and it's my job to know those, look at those, and look at what you're telling me happened. And all I am suggesting people say happened is declare this endorsement. Don't talk about what's in the judgment, because then you're allowing the judge to put on his legal doctrine of fairness hat is, I have this power. I can just say what I think is fair. No, you just want to know, what's the standing law? What's the constitutional law? Does he have to invoke the court or not for this to have governmental force? So that is what I've been posting about as I have read all of these cases. And additionally, after I read Carper v. Fitzgerald, I also stumbled upon, and let me just interject that there's not a part of me that doesn't believe that the fact that I, who really knew nothing of the law prior to this, am stumbling upon these particular cases. There's millions of published cases, and
Sure.
the fact that I'm finding these, sequence of each other is divinely guided, in my opinion, because there's no other.
And the description of this here, guys, in the description for, if you're watching, you're still with us and watching and understanding, because this is going to be one of the interviews. It's probably going to take you two, 3 times for you guys to go over again. We're gonna place all the case laws and where you can find them on the description for you to do your own research, because there's a lot of discrepancies in courts, and a lot of people say no, there's not. No, there is. I've gone through it. I've seen it. I've gone through it in some cases and some judges, and it's irrelevant. And I've heard a lot of things coming out of Texas. You're in Ohio, so this you're talking about a power that was instituted to the United States, and where the state has not using its member to be by itself, the body and then to do whatever they want to do, and that's basically what's going on here. Now, what happens is, if it's recorded, not recorded, are you finding a lot of, how can I say? We find that the judge signed here in this county, did the same thing in this county. Is it a habitual?
Yes, I have been sent people's decisions from 27 different states. I have yet to get a decision. Some of them are they're just people's initials. It's not the entire name of the judge, and it just says judge underneath. I mean, it's so, once I have read this, it's like counterintuitive. How does anybody get a decision written like that and on its face believe that that is lawfully enforceable? But we're all brainwashed to, number one, trust attorneys. Number two, trust the system.
Which you guys shouldn't do. You shouldn't trust an attorney. Never, plain and simple.
In my humble opinion, I agree.
And do not tell them exactly what happened. You tell them, this is what's going on. Get me out of this situation. This is what I want. Don't tell them the full thing, because they will turn around and throw you under the bus. And here in Webb County, Texas, if you can trust 3% of the attorneys, it's a lot.
Well, I think it goes beyond even that. It's not, they are put in a position where their own self-interest is leveraged. When something like this is in motion, this is systemic. It's so large that you almost, for someone to act in opposition of it, it's kind of like they would be a whistleblower in a way, and they would not,
because they are officers of the
their
court.
career would not survive.
And let me tell you another thing. I think we need judicial reform. That's something that we need. We need term limits with these judges, starting from the state, the Supreme Court of the United States, all the way down. You need term limits on each one, because you get some of these judges that go in there and they become little deities. And they do whatever they want, and it's enough's enough. There's a lot of wrongs going on right now in this country, and I think judicial reform is one of them. I have never seen such degradation in a profession as I've seen with attorneys here, and how they'll sell out their client for anything, and I would say sell them out. They'll just give them away, probably because they have another case with somebody else. Oh, I'll give you this one, but guess what? On the other case we have, you give me that one. I don't know what's going on, but it's a pretty bad element that's in there, and it's just and I'm just making an example of what things occur. I've seen motions that are added into cases that you all never discussed about, and all of a sudden you're there like, wait a minute, what happened? When did we discuss about this? Oh no, and you go back and try to fix it, and all of a sudden they'll label you. Attorneys will label you in openly. Oh, he's a conflictive client. He's an aggressive client. He's doesn't mean well, and everybody just finds him as law, but you can't say anything about them. And it's pretty bad the way it goes. It's pretty bad in what is seen in the court. So believe me, I see what your research has done and where it's coming from. And I think people need to be a little bit more vigilant about it. But again, if you bring it up to your attorney will bring you in court and goes, oh, he's being very conflictive against me, so I don't want to represent him anymore. And all of a sudden now you're stuck. And that's what happens. And these people, the bar's not going to do anything about it. They're all attorneys. They're protecting. They're all fraternal brothers and sisters from Ivy League and the colleges and so on and so forth, and they all know each other.
Well, it's kind of like, the analogy to make is of the mob. If you're in the mob, if you go into, we've all seen the movies. If you become part of that organization, you're a rat if you don't conform and comply. You must do what is happening within the organization and support and protect the organization. So even though your job on its face is to help protect interests of your client, that is not where their even sworn allegiance is. And that's been also proven, and now I think it's in the judicial conduct book, I don't know, but an attorney's first allegiance is to the court. And the way that they argue this is that if the public loses faith or belief in the court system, well, then our society certainly implodes, right? Because then we don't have law. We don't have law.
Bridgette, I'm going to tell you one thing. A lot of people now have gone into pro se litigants, and they'll go in there and say, I'm going to represent myself. And as soon as that happens, the lawyers come out and say, oh, you see, he's a conflictive individual.
You're crazy. You're a problem.
Look at what he's doing. He's right-wing extremist. Look at what he's doing. They'll label you left, but you can't label them, because then they all get I tell you straight out, you said it right. They have a mob-like mentality. They act like the mob. They run around, a vast majority of them. I'm not saying all of them out there, please, because not all lawyers do this. Some of them are decent individuals, but the vast majority are hitting happy hour and trying to go out with your young daughter and stuff like that, and they think that it's all fine and kosher because you can't do anything to them. They're acting like the mob. In fact,
I think there are well-intentioned people.
Mobsters act better than they do.
Well, they have more of a code of ethics about who they go after, right? They don't just go after innocent civilians. They have their targets, but they have their reasons, right? Mobsters don't just, but attorneys and judges, they just go after everybody. Everybody. You're not one of us. You are going to lose. Period.
Okay. Something just lost a little bit. Repeat what you said again.
So I said, what's happening is judges are writing entries and orders, signing them just as a judge, that says, oh, you have small children. I'm then going to appoint a guardian ad litem, which is another attorney, and you have to pay them. And then they go through the process. That guardian ad litem ultimately bills out, say, $40,000. Well, this judgment has never been recorded. That order has never been recorded. It's not lawfully enforceable, yet the parties have now paid their buddy. Basically the judge is saying, oh, I'm gonna invite a few friends into this controversy, and you just have to pay them for being, for writing a couple documents, a few recommendations. And you pay them all this money, and then, I believe then the guardian ad litem, the judge, they're all going to Tahiti together on your dime. So what do you call that? That is extortion, is it not?
Well, let me put it to you this way. The best way, not extortion, but how can I place it? The kickbacks come into the judges. It's called campaigns and campaign funding. All these lawyers throw money to the campaign fund of each judge, and guess what happens? All of a sudden, they start winning cases. The guy couldn't write left and right, and he couldn't win by his own lonesome. So he'll pay the judges, and you see that here in Webb County. Like I said,
but it's even more than the contributions. I think literally, if you have all of that income stream coming into and through a case, like, hey, you're a psychologist, will you be our expert? And we will assign every time we want to take or impact a child custody case, we're going to say, let the other party, they work in concert. The one party's attorney says, I think they're a little unhinged. They have some mental problems. Then the judge says, oh, you do? Okay, well, that's enough for me. I order you, parent, to go to have a psychological evaluation. You can't do that. They aren't trained.
And you are exactly correct, because I've seen that happen. I've seen it, the way they act, the way they behave, and half of them are degenerate, if you want to put it this way. A large percentage of them, it's bad. It's like, I don't know. Like I said, we need judicial reform. And judicial reform.
No, I really believe this is really important, because this other case, Pittman v. Byars, I'll put it up here so people can see, but we will have a link. But anyway, it further states that though a judge of a district court may decide certain matters in vacation and render judgment, yet such judgment, whether interlocutory, meaning not final, or final, is not the judgment of the court over which he presides. I mean, it's right here. That's nothing. That's not a judgment. So you, judge, writing an order saying, I'm appointing this guardian ad litem and I'm ordering you to pay him, that is criminal. It's straight up, you're operating with zero jurisdiction whatsoever, because you haven't invoked your jurisdiction. You know how they say when you file a complaint, you have to prove to the court they have jurisdiction. The judge is not proving that the court ruled under its jurisdiction. That is huge.
Put that case back up on the camera.
There's another one.
Go ahead. Tell me the next one.
Pittman v. Byars, Supreme Court of Texas, in April 21st, 1907. The next one, I'm so bad. I didn't pull it, to have it readily available. It is in my TikTok, and we can link it, in whatever link you're going to put up.
Sure.
And explain which case law is saying what. But, if you trust me to tell you what it says, it basically says, unless a state statute specifically lays out certain power that they will grant a judge operating in vacation, then they cannot adjudicate those state laws. So custody is a derivative of a state code or statute. It is not
Correct.
federal. So, but like, for example, in Ohio, I looked up our revised code that governs custody matters, and all of it clearly states the court. So there is no provision, there is no allowance for an in-vacation entry that has to do with custody or the appointment of a guardian ad litem. Yet they do it every day. Every day they appoint these attorneys to represent the children's interests in vacation. And there's no, lawful power bestowed them in their state even to do that. So
Right.
it's a violation of the Constitution, and it's a violation of their own state constitution and law. And that, to
Absolutely.
me, is the argument.
You made a couple of, you made some good points with that, but now here's a question. And here in Texas, and probably in other states as well, you also have a lot of associate judges.
Yes.
A court has 2, 3 associate judges. Are those associate judges, do they have the power of elected? No?
No. There's one.
Is there any case law on that?
Well, they're not officers of the court. So
Why can't they be officers of the court?
because they are assigned by the judicial body of that state, but they are not. That's why we have elections to our county judges. I don't
Right.
know, but people will have to look at their state constitution on how the legislative body conferred power to the court. And it specifically states in the state of Ohio that judicial officers are elected. So those are, say, our common pleas court has 15 judges, and then they split that up into divisions. Probate has 1, domestic relations has 3, and all the rest are on civil, just straight up civil matters. But those are the only officers of that court. In Ohio, we now have more magistrates. We call them magistrates in Ohio because it mimics what they call them in federal court. But a
Right.
magistrate can act per the judiciary, writing their own rules. A magistrate can act just like a judge. They can sit in trials, they can sit in hearings. You have to know you have the right to say, nah, I don't want that guy, in the interest of judicial economy. Like, why are we going to spend all this money where I come and adjudicate my matter before this person, but they're not the officer, so they don't have the final power of law? What they have to do is write a recommendation, or they write an order, and then the sitting judicial officer must sign it. So unless the parties know, and of course, attorneys are not informing people, in my opinion, that this is so. And so they are letting magistrates who don't have the power of the court, period, because then the risk, do you see what I'm saying? It's a way to deflect any risk off that judge, because that judge doesn't necessarily, I mean, even the people elected, they don't necessarily, there are some judges that are like in example, in my case, it went to 2 other judges and they both immediately recused because they're basically saying, I know what is expected of me to do to that person and in that case. And no, not me. Don't pick me. I don't want to do that. I don't want to actively defraud that person. I don't want to use the power of this office and write fraudulent documents. They're not coming out and exposing the system and that it happens, but they're electing to remove themselves from doing it. So there are those people within the courts. And the way to deflect and take all that pressure off is we're going to assign a commissioner. we're going to assign a magistrate, because they are administrative only. They do not ever possess the power to adjudicate anything of law. So that is why they're doing, I believe, all of the magistrates, and what do they call them in Texas?
Associate judges. They also have magistrates here as well.
Okay.
So
Yeah. Well, the associate judge is, I think they just pick a bunch of fancy names for, these are like law clerks to me. I don't know. I mean, I don't mean to insult anyone who has that position and they're doing it honorably, but they don't have the office. That's all I can say. They don't, and that's a fact. That's a lawful fact.
So basically, if depending on the state by state, if the state legislation says that a judge or of this court can appoint this, and if it's written by the state, then it can go through. If not, it's not.
No, I disagree with that. I'm saying that the Constitution of the state, read what your Constitution requires. If the who is an officer on the court? The officer is the elected person. That's the only officer. So the judiciary can't confer power to another person. They can't say, well, we want more officers. They have to change their state constitution to get more officers on the court. Do you see what I'm arguing? You can't, the judiciary can't say, we need a lot more judges.
No, I see where you're coming from.
Right.
I see where you're coming from.
So those people are all administrative people empowered by the judicial body of their state. That's not an officer of the court. It's what's in the Constitution. Those are the people that are considered able to adjudicate law and sign for the court. These other people that the judicial body tells the state, hey, write a law that says we can hire as many as we want. Those still aren't officers. It's dictated by what's in your state constitution.
Correct.
That's how many court officers you have.
That's a good question. I think we need to. I'm going to ask for an opinion from the state. I think that's a very good question, because that's something that would stop a lot of this nonsense that's going on.
Yes, and if you have a judgment, I've had a person reach out to me who's been in state adjudication court for 8 years. He does not have a single order or decision or entry written by a judge. Not a single one. They're all magistrates.
I believe it. And I think that's some great information. Folks, if you guys like what we're talking about, click like, share, comment. Tell us where you're commenting from, because there's a lot of discrepancies in court. And I do believe now is a time that we do need judicial reform. And not only that, there's a lot of reforms: prison reform, school board reform, there's police reform, all kinds of stuff. Now is a time we need to do that. And the only way this is going to stop is if you actually put term limits on every public elected official. And it needs to happen, because a lot of these people, they get into a bad habit, and guess what? Those bad habits turn into a culture, and this is what we ended up with. So,
well, and I also believe we need to bring back a federal law requiring the seal of the court.
Yep,
I personally believe we need to lobby Congress to bring that back, because you need to know that your judgment, whether you let them serve, for a year, 4, 10, whatever, indefinite, they could still do a lot of damage in a year if they're writing judgments that aren't of the court, and the state is enforcing those entries. Because, where do you go? Like this says, you can't go to a higher court. And if the state's enforcing your judgment that has no governmental force of law, how do you defend yourself? So we have to have a very well understood and known way for a party, a person, a litigant to understand that that decision was entered into by the appropriate authority. That's what we have to know. And telling us that a person is a judge is apparently not, sufficient, because they have some, I don't want to say it is secret knowledge. It's like secret, they have buried it for decades now. More than 100 years they've buried it.
That's, and you have to, people need to research, go out there and research. Don't take anything as gospel.
Right.
Go in there and go in there, do your research. If it pertains to you, continue going forward. How can they get a hold of you through TikTok? What's your how can your handle on TikTok?
Hopefully we can put that up with, in the link. But it is the initial B, then BYRNE DAVIS 2.0. So B Burn Davis 2.0.
Awesome. And I want to thank you for
thank you for having me.
No, thank you. Thank you for your time, and thank you for coming on board, and keep doing what you're doing, because you're educating a lot of people that are out in the dark, basically.
Yes, well, thank you. And again, I believe someone really powerful is helping, because I think this has exploded. They have created an entire marketplace around these state matters, these state court matters. And, I personally believe in God, and I believe God is, calling time, like times of that. We are all going to tell each other what is really happening.
Absolutely. You folks, we're going to end this now. Number one, I want to thank you for coming on board. And folks, how do we leave you guys? You all stay safe, be safe, and God bless you all. Until next time, much peace.
Thanks, Paul.
Thank you, Bridgette.